Hi, everyone. Welcome. Tonight we are talking about the expansive public charge rule that has been halted and is no longer in place. This is really great news for green card applicants because this public charge rule that went into effect in 2019 and then was working through the court system and on again, off again was really a giant hindrance. It was a huge problem for a lot of people. So tonight we're going to talk about this rule that is no longer in place, what it means that the rule is no longer in place, and what you need to be aware of for public charge purposes going forward. So the Biden administration announced earlier this month, so earlier in March, that it was going to stop the public charge rule, which was a Trump-era policy that made it harder for immigrants to obtain green cards. That decision was on the same day that the Supreme Court made a ruling actually dismissing a series of pending appeals over this controversial policy. So the public charge rule was not new. It wasn't something that the Trump administration came up with. The public charge concept was actually first established by Congress in 1882. And this was to allow the United States government to deny a U.S. visa to anyone who is likely at any time to become a public charge. But this 1882 rule didn't define what public charge actually meant. Typically, however, for the last several years, people who are likely to become public charges, meaning they're reliant on the government and unable to pay for their own expenses and care, they've always been ineligible to receive a green card. However, in 2019, the Trump administration dramatically expanded the public charge rule, expanding the definition, adding additional requirements to apply for a green card. And these were exceptionally onerous requirements, and they were meant to limit legitimate immigration. It wasn't something that was actually helping our system. It was just a policy to limit who would qualify, even though they had a financial sponsor or even though they had a job or training that they could have otherwise been eligible for a green card. So there was a new form required. It's called the I-944. And a lot of new evidence that was required to go along with green card applications for most categories. And one, the rule would bar anyone who had received certain types of benefits during a certain time frame. What's important to recognize, though, is that the great majority of people who are applying for green cards are not even eligible for the benefits that the Department of Homeland Security, that this new public charge rule was trying to penalize. And on top of that, they were requiring a very complicated analysis about the potential need for future benefits as well. Some organizations had projected that nearly a half of marriage-based green card cases would have been denied under this new analysis and under these new requirements. And even more than half of parent-based green card applications as well. The rule not only were we worried about potential denials because of this public charge rule, but it also just had a chilling effect. Many people were afraid to apply. A lot of attorneys were telling people to hold off and not even apply, but also it was really costly with time and money. Even if you qualified without any problem, the amount of evidence that you had to pull together because of this new rule was extensive. And because of the amount of evidence, because of this new form, attorneys were having to charge a lot more to prepare a basic a basic marriage-based adjustment application, or one for your parents or siblings. So it was really a problematic rule for many, many reasons. Many organizations sued to stop the new rule, and it had made its way up to the Supreme Court. And that's where we were just before the Biden administration announced that it was no longer going to defend this rule in court. And since the Biden administration wasn't going to defend it in court, then the Supreme Court had to dismiss it. Or the Supreme Court did dismiss it because the government wasn't going to be there to argue why they should, in fact, find that this rule was fair, that it wasn't arbitrary, and that it should continue. So on March 9th, the Supreme Court dismissed the pending appeals over this public charge rule. And then USCIS announced that same day that petitioners were no longer required to provide the information on public benefits and financial standing that was required specifically by the public charge rule. And then USCIS also removed the I-944 from their website. So it's no longer there. It's no longer required along with your application package. And if you had a request for evidence that was based on sending the I-944 or evidence required or specific to the I-944, then those requests for evidence no longer have to be responded to. However, if you did receive a request for evidence that included information relevant to the I-944 and something else, then you would still need to send in the documents required for the other part of the request for evidence. So don't let that part slip past you. Now, following the abandonment of this new expanded public charge rule, then USCIS has reverted back to applying the 1999 interim field guidance to applicants for adjustment of status. So you can't just go out and get all the government benefits that you can find and still be eligible for your green card. That's not how this works. USCIS still has to decide if you are likely to become a public charge, so there's still an analysis involved. However, it's much less onerous. It's much less extensive. And what they're looking at is they're looking to see if someone will be primarily dependent on the government for public cash assistance, for income maintenance, or institutional long-term care at the government's expense. So now they will overlook, or rather receiving certain types of benefits will not make you ineligible for your green card. For example, Medicaid, except for long-term government expense, public housing, or receipt of SNAP benefits, the supplemental nutrition assistance. Again, most people who are not a green card holder are not going to qualify for these benefits anyways. So it would be an unusual situation if you qualified for them. But if for some reason you did in the past, and now you're applying for your green card, now they should be looking forward to say, okay, even if you receive these for a limited amount of time, what is your situation now? What is your family or what is your spouse's income? Does it look like you're going to become a public charge again or not? And you don't have to send in, or you don't need to send in all of the additional requirements that they were looking for the public charge analysis. Now, it's important to remember that asylees, so a lot of our clients, a very large percentage of our clients are asylum seekers or asylees, and this public charge rule never applied to them either way. So that is helpful to know, but even though we would tell clients that asylees and asylum seekers who are adjusting their status to a green card holder are not subject to the public charge rule, they were all still very nervous and very worried, and it was hard to understand how their green card wasn't subject to this, but other people were. And so they were actually going without services that they were legitimately eligible for because they were worried about this new rule. So now the new rule's out the door. You don't have to worry about that. And of course, the great news is that the green card applications for spouses and family members are more straightforward again. Now we're looking at, does your sponsor make enough money to pay for you, for your household size? Do you have a legitimate relationship with that person? If it's your parent, if it's your child, if it's your spouse, we're back to the nuts and bolts of the relationship and whether or not your spouse can sponsor you, and not looking at all of these additional documents that really made the process much more difficult, much more complicated, and not really helping in terms of deciding if someone was truly eligible for a green card or not. So if you have questions about this, I am happy to answer them. Please drop those into the comments. Even if it's not related, you're welcome to ask, and I'll take a look and answer what I can. But hopefully for many of you, for your friends, family members who were holding off on filing the green card because of this new tough public charge rule, it's gone for consular processing cases, it's gone for adjustment cases, green card cases in the US. So this is big news. This is going to be a big help, and help with the cost of attorney's fees and your time and your sanity, because it was really a huge headache. So let me take a look at the questions that we have. And one question is, I've been granted asylum recently, and what is my next step? What is the process to file a petition for my family back home? That's an excellent question. So first, congratulations. I am happy to hear that you have been granted asylum. That's wonderful news. And the next step for someone who's been granted asylum to sponsor their family, if their family is abroad, is to file the form I-730. This is a petition to sponsor your family members as follow to join asylees. So when they enter, they'll be an asylee just like you. This form requires you to also send in evidence and proof that, one, you were granted asylum. It also requires you to provide proof of your relationship. So if it's your children, you need to provide copies of their birth certificates. If it's your spouse, your marriage certificate. But also with these I-730 applications in the last year, USCIS has been much more restrictive on what they're accepting and requiring a lot more additional evidence. So just be careful when you send that in. You're going to want to provide extra evidence of your marriage, for example, in addition to just your marriage certificate. You're going to want to submit evidence that this relationship was real, that it was entered into when you said that it was, that you've continued to be in a bona fide relationship, that this relationship is for love and not for immigration benefits. And similar with your children, depending on when their birth certificates were issued, depending on the relationship, if it's a biological child or adopted child, you may need additional evidence as well. So that will be your next step, the I-730. Our firm helps with those. If you would like assistance, please feel free to email us or call us. We would be happy to help with that process. And it looks like that is the only question for tonight. I hope that this information is helpful. I hope that everyone is as excited as we are that this public charge rule is out the door. We are certainly happy to be able to work on applications like normal again and not have to worry about these extra, very difficult evidentiary requirements. So feel free to call us. If you have questions, email us. If you need a consultation, we have 3 attorneys who would be happy to meet with you to discuss your case. And also, if you have questions that you would like for us to address on our Facebook Live and YouTube Live events, just let us know and we will try to cover those topics for you. All right, everyone, I hope that you have a wonderful evening, and we will see you back here at 6 o'clock next Tuesday. Bye.